Can I ask, have you been able to agree on a division of the remaining time?
My Lords, we have. My Lords, on the basis that I'm allowed till 2:45 today, the learned friend Lord Goldsmith will then take the court till 4 p.m. and then have in the morning till 12:15, and then I will reply and finish by the short adjournment tomorrow. Then the afternoon can be dealt with the respondent's notice on a de bene essay basis.
Oh, I see. Right.
My Lord, your Lordship was hoping that we'd managed to get to...
Well, I thought I was perhaps going to experience a pleasant surprise, but apparently not.
My Lord, we've agreed to shave equal amounts off the time for our submissions, but, my Lords, only your Lordships can impose more control.
Yes, I understand.
My Lords, before going to Adali, I just need to finish off on Sedley Denfield and say two things about it. On Delaware Mansions, and say two things about it. The first thing about Delaware Mansions is it's an allowing case. The defendant's liability arose from non-abatement. They were not doing anything. They're allowing something. They had the relevant knowledge of the hazard and took no steps to abate the source of the nuisance. The planting of the tree, we know, happened in 1900. We know the City of Westminster was established as a statutory body in 1965. Nobody knows whether Westminster, or a forerunner of it, planted the tree, but that's not really the point, because if the planting of the tree was the nuisance, then the claimant would have been well out of time. So it's not a creation case, because Westminster are not being sued on the basis that they created the nuisance. My Lord, what we say about my Lord Kitchen's point about the paragraph of if the plane tree had been, the sentence if the plane tree had been removed, was that that's a reference to non-abatement, which is relevant to causation, and therefore relevant to the question of whether the defendant can be liable at all. It wasn't the touchstone in the judgment of Lord Cook for whether the nuisance was a continuing one or not. And that's the difference. We say whether it was continuing or not wasn't dependent on that question of causation, which is a different question. And that's borne out by the final passage of Lord Cook's judgment. This was the last judgment Lord Cook gave in the House. And this is the last sentence of his last judgment on page 335 of the report.
Bundle page?
The bundle page will be 3498.
Thank you.
And in his last paragraph, he says, paragraph 38, in the end, in my opinion, the law can be summed up in the proposition that where there is a continuing nuisance of which the defendant knew or ought to have known, reasonable remedial expenditure may be recovered by the owner who has had to incur it. In the present case, that was Flexon. So the only reference there to the defendant is in relation to the requirement of reasonable foreseeability. So long as the nuisance is reasonably foreseeable, the claimant's entitled to recover for remedial expenditure as long as the nuisance continues to interfere with their land. And the focus for the purpose of continuing nuisance, not necessarily for causation, but for continuing nuisance, is on the claimant's land, not the defendant's acts or omissions. And so we say that's the first thing that can be taken from Delaware Mansions. The second thing is that there is a difference between Delaware Mansions and our case. And the difference, and this also goes to the point my Lord Kitchen raised with me before the short adjournment, was this, that tree roots do require a continuing connection to the tree, to the source of the nuisance. Oil doesn't. Oil can move on its own. it can damage land, even where it's completely cut off from the source of the nuisance, which was the defective pipe. Even where it's completely cut off from the defendant's land. And therefore, Delaware Mansions, although a perfect case for saying there is such a thing as continuing nuisance, does have that distinction with our case. My lords, you could say there are three different types of nuisance. There's a single act of nuisance, like an explosion, or my Lord Burroughs' example of a house being burned down, or an escape of water, perhaps like Sedley Denfield, a single act of nuisance. And there's also repeated nuisances, where you have repeated acts by the defendant and repeated interferences with the claimant's land as a result. The classic case of repeated nuisance would be picketing cases, because the defendant's got to turn up every day afresh outside the claimant's property and cause fresh interference by each act of picketing. And then thirdly, there's continuing nuisance. That's our case, where there's no repeated acts or allowance by the defendant. What's happening is there's an initial act of creation or allowance, in our case of creation, which causes ongoing interference with the claimant's use and enjoyment of the land. And what we do say is that if Jalla right, and all the elements of the cause of action in nuisance must be repeated in order for there to be continuing nuisance, then actually there's no such thing as continuing nuisance at all. There's just the two categories. There's just single act nuisance and repeated nuisance. Shell's analysis, and this is why Delaware Mansions is important, robs the legal principle of continuing nuisance of any content. And my lords, we say that can't be right, because continuing nuisance is the basis of Lord Cook's judgment in Delaware Mansions. And there must be a principle of continuing nuisance, simply because the continuing interference, in our case by polluting oil, was caused by Shell's creation of the nuisance every bit as much as the initial interference. And
if you ask that question in relation to personal injuries, you can have a one-off tort that, let's say, breaks my leg. And it may be that the prognosis is that in 25 years' time, or rather less in my case, you're probably going to get arthritis. There's no lack of causation between the long-delayed harm and the original one-off cause of action. But it doesn't mean that you have to erect a concept of sort of continuing negligence in order to recover for it. You get your recovery when you go to court straight after, even while your leg is still mending, on the basis of expert evidence as to what's likely to happen in future.
My lord, that would be so in the law of negligence, and that's so on the basis of many authorities in the law of negligence. But nuisance is different. Nuisance is a property tort. Nuisance is not about the conduct of the defendant as much as the effect on the claimant, and that it's a property tort, and therefore it's about the interference with the claimant's land. It's a completely different thing, and that's one of the criticisms we have of my learned friends' detailed submissions. We say they're constantly confusing concepts of negligence with concepts of nuisance, with property torts and non-property torts, and that's why ultimately they're forced to rely at the centre of their case on various negligence claims like Homburg, Huttenport, which we say are completely off the point because they're negligence cases.
But I mean, is nuisance and negligence, are they so very different? I mean, they're both actions on the case. The reason that we're preoccupied here with the form of the damage is because of that historic route for nuisance, that it's an action on the case, therefore there's no cause of action until you have damage. And that's true of negligence as well.
Yes. But, my lord, we say they've developed in different ways, and that the essence of negligence is a focus on the defendant's conduct as much as on the claimant's. Because it's not a fundamental property right.
But I mean, there's obviously some focus on what the defendant has done in nuisance as well.
There's foreseeability, there's reasonable use.
Well, there's also whether they've acted in a way that has created the harm or have failed to abate, your two examples. So there's some element of action or inaction which, on the part of the defendant, which is treated as a necessary ingredient of there being a tort at all.
My lord, yes, that's why I took that diversion and talked about fault. That actually nuisance is basically a strict liability tort, subject to a couple of glosses in relation to foreseeability and reasonable user. Ultimately, it's a strict liability tort, whereas the essence of negligence is you must take reasonable care to avoid causing foreseeable injury, which is the principle of negligence. At the heart of it is reasonable care. Whereas in the definition of nuisance that we looked at from Lord Neuberger in Lawrence and Friend Tigers, there's nothing about the act at all, about the nature of the act. It's just an act or allowance which causes. There's nothing in the nature of the act. And so, my lord, we say they have branched off in different directions. And what I seek to do on this appeal is to bring nuisance back to being what it is in essence, which is a tort for the benefit of property owners.
I mean, but the tort of negligence can also be a property tort.
Can be, but not necessarily.
True, but where it is, I just wonder how far they are distinct. You're focusing entirely on the effect on the claimant, but our definition of private nuisance would be something like substantial unreasonable interference with the claimant's land. So you've got an element of reasonableness built in, arguably, to the definition. But insofar as you've got, I mean, let's say here, a claim which at one stage was posited in the tort of negligence, how different would that actually be on your submission? I mean, why isn't it the case that we're asking these questions about the tort of negligence?
Because there is a proper developed case law about continuing nuisance.
That you can have a continuing negligence. I mean, something like
I think that may need repeated acts of wrongdoing.
No, I mean, if you've got something like a professional negligence claim and somebody fails to register, Midland Bank and Stubbs and Kemp or something like that, you've got an analogous claim between the breach of contract that's continuing and the failure to exercise reasonable care, which is continuing.
Well, my lord, one might say then there's two acts of negligence. There's the failure to register, and then there's the failure to put the failure to register right.
Right.
You might say that's a repeated negligence.
Okay. But can I nevertheless just put to you that the importance of the negligence claim would be the damage to the claimant's property. There's no dispute, I don't think, well, there may be, but I don't think we're talking about whether there was or wasn't fault in relation to the spillage. Let's just assume there was. Then again, we would be purely focusing on the effect in the tort of negligence on the claimant's land.
But there wouldn't be fault within the limitation period.
Why not?
Because there wouldn't be another act of wrongdoing. There wouldn't be a repeated act of wrongdoing, which is what nuisance doesn't need.
Right.
My lord, I think the answer to this is an historic answer, which goes back to my Lord Sales's question, because the reality of the position, when I said it's gone off in different directions, is that the law of nuisance is developed in tandem with the law of trespass rather than the law of negligence. And reasonableness now in the law of nuisance is only relevant to allowing cases. It's only relevant when when it's a case of standing by and allowing the nuisance to occur. Then there's a question of, was it reasonable to abate the source of the nuisance?
Well, I'm not sure that's strictly true, because if you look at Cambridge Water, you've built in a fault element, reasonable foreseeability. I can see it's different from the fault element for negligence. So to that extent, one can say, well, nuisance and negligence have developed in different directions. But I mean, there still seems to be some fault element on the part of the defendant in order for there to be any liability at all. You have repeatedly referred to it as a tort of strict liability, but I respectfully question whether that's to put it too strongly. If it was truly a tort of strict liability, it wouldn't matter what the source was on, let's say, of the water on your land that gets on someone else's land. There was water here, there's water there, it's a flood, liable. But the law doesn't seem to work in that way.
Same, if I may say so, a case like Leakey in the National Trust would also support the view that it isn't truly strict liability. It depends, for example, on what a reasonable landowner would do with the resources and so forth available to the defendant.
But my lord, the emphasis in trespass and nuisance is about what happens on the claimant's land. And the fault, I call it a strict liability tort because of the passage in Reed and Lyons. But if there is an element of fault in nuisance, it's certainly not based on a duty of care.
I mean, forgive me for just taking time on this. You say the focus is on the damage, the harm to the claimant's land. I mean, it's true, that's an element of it, and I don't think anyone's suggesting otherwise, but that goes back to the fact that it's a form of action on the case, so you always needed damage.
Yes.
I'm not sure that one can escape the fault element or looking at the fault element on the part of the defendant as well, because you need that too to get the cause of action. It's not good enough to just say, well, the focus is the harm to the land. Let's just look at the harm to the land.
Well, if my lord was saying to me, I don't accept that nuisance is a strict liability tort, there must be some fault on the part of the defendant in nuisance, I would say to you, lordship, yes. Okay then, the fault is simply the creation or allowance of the act which causes the nuisance on the claimant's land. That's the fault.
Yes, thank you.
Can I, sorry to press this just one last time. I'm going back to the question of negligence. Your answer to me in relation to the continuing tort issue was, well, there'd be no repetition of the wrong. It was a one-off event here. What I'm suggesting to you is that you have exactly the same question about when causes of action accrue in the tort of negligence here as you do in the tort of nuisance. So, for example, if the oil had hit and damaged portion A of the claimant's land, and then 2 weeks later had damaged the house on a different part of the land, you would have, in my understanding, two separate causes of action in the tort of negligence, because they would be separate of damage.
Repeated negligence.
That would be, yes. So what I'm saying to you is, isn't that the very question that we've got to answer here, whether we have got fresh, different damage, and that is actually the same question as would be asked in a negligence claim?
My lord, I was going to come on to this, but this, I think, if I understand your lordship's question correctly, this does relate back to your lordship's previous question, which is whether we need different damage.
Yeah.
And my lord, what we say about that is some cases will involve different and separate damage, such as subsidence cases, like Darley, where subsidence happens at different times. But some cases will involve the same type of damage, like Delaware. And this is what my Lord Sales put to me. He said, well, it's the same roots. It's just the same routes there every day. And I said, yes, but they're getting longer. And he said, yes, but the bits that are not getting longer are the same routes.
Dehydrating the same.
Yes, dehydrating the same. And I tried to answer my Lord Sales's point in that way, but actually on reflection, my Lord is quite right. It is the same damage. So there are some cases which involve different and separate damage. Some cases involve the same type of damage. But both are substantial interferences with the claimant's enjoyment of its land, and the substantial interference is continuing. And whether it's more of the same or whether it's more of different doesn't really matter if the source is the same.
Right. So you're saying that even if it's exactly the same damage,
Yeah.
then that is a continuing nuisance.
Yeah, because continuing nuisance is continuing interference.
A nuisance of damage of the same kind, but you accept, as I understand it, that you can't recover in respect of damage suffered more than the relevant limitation period, outside the relevant limitation period.
Unless it's continuing, unless it's of a nature where it's possible to call it continuing damage.
But even then, you can only recover. Even then, one can only recover in respect of
Oh, yeah.
the period that is within the limitation.
Yeah, one can only recover in English law for the last 6 years, in Nigerian law for the last 5 years. Yeah, this doesn't blow open the law of limitation so that we can recover for 20 years of damage. Or it's not 20 years, since 2000.
So that's I'm very grateful for that clarification. So you are saying even if the damage is the same,
yes,
nevertheless it's a continuing nuisance,
yes,
which is what I thought was the proposition. Now, then when I put to you, what's the position with negligence? You would presumably want to say, well, there's just one cause of action, which is day one in negligence.
Yes.
So we need to understand why you would say that that's a difference between negligence and nuisance, because you might say the cause of action accrues as soon as the damages are caused in both.
Well, Lord, I think the answer may be as basic as we can't find cases which talk about continuing negligence, whereas we have two House of Lords cases that talk about continuing nuisance. It appears, because it's gone off nuisance has gone off in the direction it has, there appears to be a concept of continuing nuisance, which we say applies here. Whereas continuing negligence is not one that I can think of where the House of Lords has given its imprimatur to that concept.
I mean, I'll need to think about it a little bit more, but I did wonder whether in that last paragraph from Lord Cook's speech, this is page 3498, he might have been guilty of the slippage that you talked about before, in terms of talking about a continuing nuisance as opposed to a continuing failure to abate the source of the nuisance.
Yes, my Lord, I can see that. It's very commonly done. But
that might have significance for this argument, because if he's talking about a continuing failure to abate the source of the nuisance, then he is looking to, if you like, the fault element. We've got the fault element, we've got the harm element for an action on the case. And perhaps he's talking about the fault element there.
Well, my Lord, it's because it's an allowing case. So
precisely so, but I thought it was in the allowing cases that you said that the slippage has crept in.
Yeah. That's what I want to say is that reasonableness only has its place in allowing cases, not in creating cases like ours.
Right.
Now, my Lord, I really... I should just deal with the way that the Court of Appeal dealt with this. They sought to distinguish Delaware Mansions on the basis that it was not a case about an accrual of a cause of action, but the primary issue was whether it could be said that Flexon had suffered any loss. But, my Lord, what we say is, well, yes, but the question of timing was critical to establishing a cause of action in Delaware Mansions. The first instance judge dismissed the claim on the basis that all of the damage to the land caused by the tree roots had occurred before the claimant's period of ownership, such that the claimant had no cause of action to recover its remedial expenditure. And that's dealt with by Lord Cook in paragraphs 10 and 11 of the report of the House of Lords case. So the whole point of the claimant's appeal on the issue of continuing nuisance in Delaware Mansions was the need to establish a cause of action so as to permit recovery of that expenditure. The appeal was a success, so that result can only be explained on the basis that a fresh cause of action accrued after 1990 when Flexon acquired the property by reason of a continuing nuisance. My Lord, I have to move to Darley.
Yes, and we need to allow you time now to complete your submissions.
My Lord, I shall really be as swift as humanly possible.
You know, I was really making the point we need to exercise some restraint in questioning.
My Lord, Darley is on page 3425, and we have. We say that if your lordships, and of course this won't happen, but if your lordships were only to read one case, we say it should be this one. In their written case on this appeal, my learned friends Fushell described Darley as a case in which successive causes of action arose as a result of repeated conduct on the part of the defendant. They say that a fresh cause of action accrued because the claimant suffered further damage as a result of further excavation by the defendants or as a result of their continuing failure to ensure support. And that is an important error on my learned friend's part. It's important to start with the facts here, which are stated in the head note. The facts were that the defendants worked the coal under the claimant's land until 1868, when there was an initial subsidence. And after that initial subsidence, the defendants never worked the land again. But in 1881, 13 years later, a third party, Mr. Cooper, worked coal in adjoining land, which had the knock-on effect, or creeping is the word used in the report, of prompting further subsidence on the claimant's land in 1882. And it was agreed between the parties, this is on page 128 of the report, page 3426, it was agreed between the parties, 3/4 of the way down the page, that if the coal under the claimant's land had not been taken out, or if the defendants had left sufficient support under the claimant's land, then the working of the adjoining owner would have done no harm. So there was further excavation, but not by the defendant, it was by Cooper. And the defendant was nonetheless held liable for the second subsidence without any further excavation on its part, because its original excavation remained an operative cause of that second subsidence. So no new creation by D at all. Now, the fact that the defendants never worked the coal after 1868 is set out very clearly on the fourth line of page 3426. The defendants never worked the coal after 1868. And Shell's written case says, in discussing this, which it takes some pages over, it says, after the first subsidence, the defendant had continued to excavate coal from its land. Now, that's just not right. What's happened is that Shell have confused the excavations done by the third party Cooper with those done by the defendant. And the crucial point about Darley is that the defendants only undertook one phase of excavation, which lasted until 1868, but were nonetheless held liable for a second subsidence 14 years later. Now, my Lord, we have to start with the majority judgments, and the first is given page 3430 by Lord Halsbury. And my Lord, the key paragraph of Lord Halsbury's judgment is the one in the middle of page 3431. Now, before I go there, I should just say something about a case called Bonamy and Backhouse, which is not in your Lordship's bundle. Your Lordship has some 88 authorities, but doesn't actually have this one. Bonamy and Backhouse is a natural precursor to Darley. What happened in that case was there was an excavation in year 1, 1849, and then there was subsidence in year 5, which was 1854, and then a writ was issued in 1856, which was year 7. And the question was it time barred? And the answer was no, because the nuisance arose from the date of the subsidence. So it's a very basic proposition. And then if one looks at page 3431, in the second full paragraph of the speech of Lord Halsbury, since the decision of this House in Bonamy and Backhouse, it is clear that no action would lie for the excavation. It is not, therefore, a cause of action. That case established that it is the damage and not the excavation which is the cause of action. I cannot understand why every new subsidence, although proceeding from the same original act or omission of the defendants, is not a new cause of action for which damages may be recovered. I cannot concur in the view that there's a breach of duty in the original excavation. Now, that's not consistent with Shell's argument that there needs to be fresh conduct on their part for there to be a continuing nuisance. Damage in this context means interference with the claimant's use or enjoyment of its land. For a fresh cause of action to accrue, all that needs to be shown is that the defendant's act has caused the subsequent interference with that right. There's no requirement for fresh conduct by the defendant. The second majority judgment is given by Lord Bramwell at page 3442. And having found page 3444, a third of the way down the page, now applying this reasoning to the present case, there are, by the admission of the parties, two separate and distinct damages caused to the plaintiff by the acts, including in that word omissions of the defendants. Having found that, Lord Bramwell recognised that the defendants' acts and omissions had caused two separate and distinct interferences with the claimant's land, so there were two causes of action. We see what he says at the bottom of the page. He says, of course, one can see the danger and inconvenience that will follow. This damage accrues many years after the defendant's act or omission which has caused it. If my reasoning is right, many years hence there might be a further action from some further subsidence. But the inconvenience is as great the other way. For if the defendants are right, it follows that on the least subsidence happening, a cause of action accrues once and for all, the statute of limitations begins to run, and the person injured must bring his action and claim and recover for all damage, actual, possible, or contingent for all time. And this echoes the question from my Lord, Lord Sales, from before the short adjournment, about do you have to bring your action the minute that you get your first bit of damage. And it's important to note, my lords, that Lord Bramwell was not treating the failure to leave support as the continuing omission. That was not the basis for his decision. He regarded the failure to leave support as something that happened many years ago, many years before, when the defendant stopped working the coal. And the final majority judgment, the third majority judgment, was given by Lord Fitzgerald on page 3445. At the bottom of page 3445, he opens his analysis by putting forward a series of numbered propositions, which all relate to nuisance. And then on 3446, he identifies the cause of action that arose in 1868 as the interference with the claimant's land. He says, For although the law encourages, this is halfway down the page, although the law encourages a man to the free use of his own property, yet if in doing a lawful thing in the enjoyment of that property, he occasions damage to his neighbour which might have been avoided, he will be answerable for that damage whenever it occurs. Now, as to the cause of action in 1868, there's no doubt the mere excavation prior to or in 1868 was legitimate, and not of itself alone the foundation of any right of action. But when the subsidence of that year took place and caused damage to the plaintiff's houses, then the defendants became liable to make good that loss. Because although their acts were in the lawful use of their own property, yet the injurious consequences to the plaintiff might have been avoided. It is the disturbance then, when it arises, that is the cause of action, and not the prior legitimate acts of the owners of the minerals and the lawful enjoyment of their own property. Now, moving on, it's worth noting that on page 3447, Lord Fitzgerald, in the final paragraph on 3447, recognises that there can be no doubt that though there's been no act of commission by the defendants since the completion of the excavation of 1868, yet if there had been no subsidence causing damage to the plaintiff prior to that, the present action could be maintained. And he then goes on to recognise the problem of the problem that's been raised about when does the claim need to be brought, but nevertheless goes on to find for the claimants. And pausing there, again, Lord Fitzgerald's focus is on the claimant's land. It's the disturbance of that land that's the cause of action. And then he applies the principles to the case on the final page, 3449. He says, it seems to me that Backhouse and Bonamy did decide that the removal of the subjacent strata was an act, I will not say an innocent act, done in the legitimate exercise of ordinary ownership, which per se gave no right of action to the owner of the surface, and that the latter had no right of action until his enjoyment of the surface was actually disturbed. The disturbance then constituted his right of action. There was a complete cause of action in 1868, in respect of which compensation was given, but there was a liability to further disturbance. The defendants permitted the state of things to continue without taking any steps to prevent the occurrence of any future injury. A fresh subsidence took place, causing a new and further disturbance of the plaintiff's enjoyment, which gave him a new and distinct cause of action. It's to die in DM. It starts again every day. If this view is correct, it follows that the cause of action now insisted on by the plaintiff is not the same cause of action as that of 1868, but is in point of law, as it is physically, a new and independent cause of action arising in 1882. So he's saying there was a fresh cause of action for the 1882 subsidence because there was a fresh disturbance of the claimant's enjoyment of the land. That was the basis of his decision. He recognised, of course, that the defendants permitted a state of things to continue without taking any steps. He recognised the allowance, but that wasn't the basis of the decision. The cause of action he identified was the initial disturbance and not the support that allowed the second subsidence. So he's making an obvious point that if the defendants had taken steps to prevent the second subsidence, there would have been no further interference, but it's not the basis of the reasoning. And then the penultimate paragraph, he recognises the implications. It's worth noting, if this view is correct, it follows the cause of action now insisted on by the plaintiff is not the same as that of 1868, but is a new and independent one. So, like Lord Bramwell, Lord Fitzgerald is recognising the implications of his judgment for the application of the Limitation Act, but basing his decision on reason rather than reverse engineering the outcome. So we say that is pretty much on all fours with our case, particularly when one looks at the dissenting judgment of Lord Blackburn.
But here you've got two separate distinct damages. You've just told us that you accept that your case is the same damage.
My lord, some are going to be the same, some are going to be different, but that's not what matters. Whether it's the same or different damage doesn't determine whether it's a continuing nuisance.
Disturbance, separate disturbances here is a key element of the reasoning.
Well, my lord, just like the separate interferences with different pieces of land are separate disturbances with the oil. We also have separate disturbances.
Do we, in the case of these two individuals?
My Lord, we do. My Lord, I promised I would tell your Lordship something about these individuals. Both of them are fish farmers and own plantations. The fish ponds, Mr. Jalla farms fish, tilapia and shrimp, and he also grows plantain. His witness statement is on page 2621, if your Lordships want to learn more about him.
Sorry, 2821.
2621.
Thank you.
So he farms fish and grows plantain. Mr. Chujaw grows cocoyam, and also, which is where it's a vegetable which grows deep in the ground, and it's the stem that's the edible bit. And he also farms fish, tilapia and crocker. His witness statement's at page 2627.
And does it explain whether the fish farming is done in the sea or in, I don't know, these are, tilapia's a saltwater fish, isn't it?
My Lord, he's not been able, what he explains in his statement is that he's not been able to do his fish farming because the fish will die because of the the groundwater contamination by oil.
Right.
My Lord, Mr. Jalla gave evidence remotely in the date of damage hearing. Mr. Chujaw gave evidence in person at the date of damage hearing. That's why your Lordships have witness statements from them. But they continue to not be able to do their fish farming because the groundwater is contaminated by the oil. And my Lord, we say, well, it doesn't matter whether it's the same damage or different damage. It certainly doesn't matter to him. It's continuing damage that's the problem.
Well, he says, page 2623, paragraph 9, the land, this is Mr. Jalla, the land including both the fish farm and the plantation was completely destroyed by the Bonga spill on the 17th of December 2012.
My Lord, he has different. I think he has three different plots of land, and I think Mr. Chujaw has 2 different plots of land.
So paragraph 13 is June 2014.
Yep. Yes.
Don't think we have a date for the next for the. Oh, is that the same? Is paragraph 14 the same property as paragraph 13? Yes.
Yes, there may be different properties.
Yeah.
My Lord.
And then the last.
And then we have the last one. Yeah. September 15.
Yep.
My Lord, may I use the remaining moments I have to look at Lord Blackburn? Because this is one of those cases where the dissenting judgment does throw into light the majority judgment. Lord Blackburn's judgment starts on page 3433. Lord Blackburn's summary of the facts on page 3433 towards the bottom, 5 lines from the bottom is, the defendants had worked out the seams of coal of which they were lessees as long ago as 1868, and they had done nothing from that time. And the difference between the majority and the minority is whether that precluded a fresh cause of action arising. And on page 3437, Lord Blackburn disagreed with the reasoning of the Court of Appeal, by which the court held that independent, distinct causes of action arose from each fresh damage. He said, this is 9 lines down, he says, in this I completely agree, but I have not been able to agree with the reasoning by which it sought to be made out that it logically follows from the decision in Backhouse and Bonamy in this House that there are fresh causes of action at each fresh subsidence arising from the old disturbance of the strata, occasioning fresh damage to the property. And the reason he disagrees is on page 3440, and it's halfway down the page. He says, the basis of his disagreement is this: and if a man, in breach of the duty to take reasonable care in the management of a horse in a public street, gallops along it, no action lies, except at the instance of a person who suffered damage. But no amount of damage will give a cause of action against the owner of the horse unless a breach of duty is shown. And I think there is a duty in the owner of land on which his neighbour's land rests to respect it and take care that he does not injure that support. So that's rather redolent of mixing up negligence with nuisance. And there are various points can be made about Lord Blackburn's response. Obviously, the first is it doesn't represent the law, the majority judgments do. But more fundamentally, the approach, the error made by Lord Blackburn, we say, on a true assessment of the law, was to approach Darley on the basis of negligence reasoning rather than nuisance reasoning, focused on the claimant's enjoyment of the land. Lord Blackburn starts with a case of a negligent failure to control a horse and reasons it from there. And the conclusion of that analysis, given where it started from, is unsurprisingly, is that for there to be a fresh cause of action, there must be a fresh breach of duty by the defendant. But that's not the right approach. That's not the majority approach. The majority approach is the tort of nuisance is different from the tort of negligence. Principles are not the same. Nuisance looks at the harmful result rather than the defendant's conduct. And the key thing is to emphasise the real point of difference between the majority and the minority. Lord Blackburn was saying there couldn't be a fresh cause of action without fresh conduct by the defendant. There was no fresh conduct on the facts, so he says no fresh cause of action arose. The majority disagreed with that. They said there could be a fresh cause of action where the same original conduct of the defendants caused a second interference with the claimant's land. In other words, the point between the majority and the minority is the same as between Shell and my clients in this case. The majority agree with my clients, and we say that's fatal to Shell's argument on the issue. Now, my lords, they bolster their argument by reference to various negligence cases, which I shall let them develop, and a distinguishing of Darley in the Court of Appeal in the Homburg negligence case, which we say is not distinguished on the basis that properly reflects the judgments in Darley.
Just before we leave this, can I just note there's Lord Blackburn cites on page 3441 an interesting passage dealing specifically with nuisance, the last full paragraph on the page, where he cites Whitehouse and Fellows, an action for maintaining a nuisance, which from time to time caused fresh damage. He's citing this with approval. He quotes the judge there saying that no fresh cause of action arises from each fresh damage. But where there's not only a fresh damage, but a continuance of the cause of damage, such continuance of the wrongful act which caused the damage constitutes a fresh cause of action. So on that view, it isn't simply that you have fresh instances of damage, but you have both a continuing wrongful act and
yes,
fresh damage caused by it.
And my lord, he's in the minority.
Yeah, oh yes, of course, he's in the minority. Yeah.
Yes. And we say that actually, when one reads Darley carefully, it's on that point that he's in the minority. My lord, I've gone 5 minutes over and I have to stop because I've made an agreement with Mellon and friends. So I'm not going to summarise what I've said, except to say, yes, this is not a case about limitation, it's a case about when the cause of action in nuisance accrues, given what the nature of the cause of action is. And the nature of Shell's response is that we are in some way trying to circumvent, avoid, distort, suspend the rules of limitation. We're not. Limitation rules apply to causes of action by reference to when they accrue. The issue between the parties is when the cause of action in nuisance arises. And obviously, there are important policy reasons for limitation periods to protect courts and defendants from stale claims. But the whole point here is this is not a stale claim because the nuisance is continuing, the damage is ongoing. The claimants continue to suffer. It's very much a live claim, which has not yet expired, to the detriment of the claimants. And that's why they say that the well-recognised notion of continuing nuisance governs the position. My Lords, I don't know if I can help your Lordships anymore.
Thank you very much, Mr. Seidler.
Lord Guildford. My Lords, it is a case about limitation, and I'll come back to that, but not start with that point. What it is about what is a one-off escape of oil from an underwater riser connecting the Bonga FPSO to a single-point mooring system, as my Lords know. We know that the spill started at some stage in the early hours of 20th December 2011, and it lasted for 6 hours before it was shut off. And there were no further escapes of oil from the Rutschwood pipe after it had been shut off. It happens that we say it was cleaned up at sea, and indeed there's a lot of evidence supporting that, which Mrs. Justice O'Farrell dealt with, but that's not so much the point. She said, after hearing the date of damage, the evidence, I'll come back to that, if any oil did reach the shore, it would have reached the shore within days, by the 25th or 28th of December 2011, actually mirroring what Mr. Justice Stuart Smith had said in his initial judgment. That's her date of damage judgment at paragraph 161, Roman 4, the reference to which in the core bundle, in the record is page 6555. Now, we say that if there was a cause of action in nuisance, it accrued at that point of time, in late December 2011, and that's when the applicable limitation period started to run. It expired, we now know, 5 years later, because that was the effect of Mrs. Justice O'Farrell's judgment, having heard expert evidence on the Nigerian limitation law, which is a full 12 months before the claims against the Nigerian defendant were commenced in December 2017. And over 3 years before the claims against the UK anchor defendants, now only one, were validly commenced in March 2020. That's why we say the claims against the anchor defendant are statute barred, which means that the appellants cannot establish jurisdiction for their claims. My Lords know all that, but important to remember that's what it is. It is a case that the limitation was the remaining piece of the jurisdiction puzzle, as it were. We've explained all this in our printed case, page 516, but more comprehensively it's set out in Mrs. Justice O'Farrell's judgment, which my Lords have at pages 6520 to 6530, particularly paragraphs 1 to 11 and 30 to 52. Now, we know, and this has been commented upon several times, that the appellants chose to wait 6 years before they brought the proceedings against the Nigerian defence, any proceedings. In order to avoid the limitation issue, they raised a last-minute argument that the alleged failure to remediate the damage, that's what they said at the time, caused by the oil spill gave rise to continuing cause of action in negligence and nuisance. They then dropped the idea there was a continuing cause of action in negligence, but maintained the argument as to nuisance. They dropped the argument there was a failure to mitigate, a failure to remediate, and they now accept that there wasn't a primary duty to remediate. I'll come back to that. But they are now saying, and this seems to be very clear, that the mere presence of the oil on land, as they assert it was, it's actually doubtful how much there was, if any, but that's not the point for now. the mere presence of oil on the land amounts to a continuing cause of action, i.e., a new cause of action each day that the oil remains on the land. And that is essentially the issue. The issue has been formulated in different ways at different points in the case, particularly by my learned friends. But the fundamental question for my lords is whether the alleged persistence of oil on the appellant's land can, without more, give rise to a continuing cause of action in nuisance. And I'll come back to what we mean by continuing cause of action. It's not a magic formula. It means, is there a new cause of action each day? So that's the issue. Now, the next introductory point I want to make is, in our submission, respectfully, there's a very short answer to this appeal. And it's this. There is a continuing cause of action in tort, nuisance or negligence, doesn't matter which, or Rylance and Fletcher, that requires a recurrence of all the constituent elements of the tort. So there must be a continuing act or omission on the defendant's side, as well as continuing harm or damage on the claimant's side. We say what that means in nuisance is the defendant must continue to do something on its land. And my lords were quite right to put to my learned friends, surely there's some fault element by the defendant here, not just damage. Then the defendant must continue to do something on its land, or continue to fail to do something on its land that gives rise to harm or damage on the claimant's land. So fundamentally, a continuing cause of action gives rise to fresh limitation actions, DA and DM, because it amounts to a continued repetition of the tort. All the elements of the original cause of action must therefore be repeated DA in DM. And there's nothing magical or strange about this. Continuing cause of action is not something that's plucked into the statute of limitations. It's simply the fact that if you have a new cause of action, time starts to run again. If you have a new cause of action each day, time starts to run again each day. And the short answer in this case is because there was no repeated act or omission on our side. It was a one-off or isolated incident, even if we assume that the harm persisted. And we say that's consistent with all the authorities. Importantly, and I'm anticipating what I will say, there is no continuing duty to abate like there was in Delaware because we didn't have control of the tree roots. Or of the tree itself, actually. You could have lopped the tree, you could have removed the tree, or cut the branches back so that the tree roots did not continue to desiccate the soil and damage the neighbour's property. So there was a continuing omission to abate in that case, and we don't have that here. Third introductory point I want to make is, if the appellants were right, there would be surprising consequences. First of all, it would upend limitation law as it applies to nuisance claims. If they are right, there'll be a continuing cause of action in nuisance, giving rise to fresh limitation periods for so long as the consequences continue. So long as the consequences or harm endures, there will be a new cause of action. And that would upend limitation law in relation to nuisance, because it would mean that the limitation period in isolated one-off cases could be extended for so long as the effects of the nuisance remain unremedied. That's actually what they initially argued, though they've adjusted their argument as the case has proceeded. And that would disapply limitation law. It would mean that incidents that happened decades ago could still give rise to in-time claims. And the courts would be forced into the position of having to establish whether what gave rise to that isolated incident was wrongful, even though the events could be several decades old. And my learned friend says this is not stale. It most certainly is stale, because, for example, just the question of was there fault in relation to the rupture of the line, that's now 12 years old. Look at the date of damage judgment and see how much difficulty there was in discovering what had happened, even closer in time. It was, and I will come back to that, it was frankly impossible for Mrs. Justice O'Farrell to deal with some of it for that reason. And I'll come back to what the evidence actually was, a lot of which was actually very unsatisfactory. Secondly, it would mean that continuing cause of action and nuisance are fundamentally different from continuing cause of action in other torts. I admire my learned friend, but it sounded like there's a magic dust called nuisance dust, which if you sprinkle it on a tort, it gives it a completely different character from its allied tort in negligence. No reason why that should be so. The consequences of an act or omission in negligence might also endure for a very long time, but that doesn't mean that the cause of action continue to accrue de die in diem. And I want to distinguish that from a different question, and in my respect for Mr. Mann, kept on falling into the trap. The damages for which you are liable is not the same question as is there a new cause of action. It may well be you cause a nuisance and you leave the property, you have nothing more to do with it, you still may be liable for all that has flowed from that original act, whether it's negligence or nuisance. But that doesn't mean there's a new cause of action each day after the day that you initially caused it. Skip this. I mean, we actually think, I'm not sure how much time the Lordships wish to or ought to spend on Mrs. Justice O'Farrell's judgment, but it's interesting just to identify just what happened, and my lords can follow it through from the judgment, which I respectfully say is a careful, thoughtful, and comprehensive judgment, at page 6516, which we have. Of course, it came out after the printed cases, so they don't take account of it. But it did follow a 4-week hearing with a substantial number of witnesses, both factual and expert. And that was, of course, intended to deal with the point which had arisen on, I think, on the 19th of September 2019, when Mr. Dunning, then appearing for the claimants, said, oh, well, it may be they suffered damage on different dates. Mr. Justice Stuart Smith said, well, I can't decide that. And so there should be a trial on that. And that's what we ended up having. They were given the opportunity to set out their case. Actually, they were given around 16 months with successive extensions to set out their case. All that's explained in Mrs. Justice O'Farrell's judgment. And she found, and this is to be found, it may be just worth looking at this, because it's page 6555, my lord's record. 6554. We did suggest that there were passages of this judgment that my lords might wish to glance at, but if I just take my lords to this, 6554, which is paragraph 161 of Her Ladyship's judgment, where she says that drawing together the findings set out, she's very detailed technical questions, having heard all the evidence and considered the material. And she found at 161 Roman 6, well, she found, first of all, that Roman 4, that any bongarole would have reached the shoreline between the 25th and 28th of December 2011. Would have reached. Yes, would have reached. So there was an assumption that some did. There's still a question as to whether any did, but assuming some did, it would have reached the shoreline in late December 2011. But as to the amount of it, she found on the facts that the amount is Roman 6, that it was a small amount. 5 was a low amount, smaller than the original. The reference to EP, those were the claimant's experts. And in Roman 6, that it would have been heavily weathered. And that is significant, my lords, because it affects whether or not it would have been seen as an oil spill, whether or not it had toxic properties, lots of different consequences, including what Her Ladyship said at paragraph 167, that it wouldn't have had sufficient viscosity to form persistent masses of oil. Sorry, thank you. She says also at paragraph 183 that there were aerial surveillance photographs taken, and they showed that the length of the coastline was actually unaffected by oil, save for 2 isolated potential oil leaks, and she identifies where those 2 places were. Significantly, and this is at paragraph 184, she accepted the evidence of Professor Duke about the extent to which this would have damaged the mangrove. This was an important point in the case. A lot of play was made of damage the mangroves and how significant that was. But what Her Ladyship found, having heard the evidence, was that there was said there was no. Sorry, it's paragraph 184. There was no evidence of any mangrove damage or dieback in 2012 or subsequently. It's in the middle of that paragraph. Now, it's significant in the light of the questions put to my learned friend about was there new damage, what damage was there, that actually it was looked at in detail by Mrs. Justice Farrell with expert evidence and factual evidence, and actually there's very considerable paucity of evidence that there was damage. And paragraph 187, the claimants had to explain one thing. As it was clear, and Mrs. Justice Farrell found, that any oil that did reach the shore would have reached the shore quite soon. How did it get far inland? Because that's what was being claimed. And so there's a lot of evidence about that. There were theories put forward by the claimant's experts, which involved the oil being stranded on the shoreline or in other places in the estuaries and then being remobilized and traveling to different parts. And that was necessary because the claimants needed to show that the damage happened quite a long time after the spill so as to get over limitation. But she found, paragraph 187, there's no evidence that those factors resulted in any stranding of substantial quantities of oil that could have remained dormant for 2 to 3 years. She said at paragraph 190 that any oil that remained would have been highly weathered in nature, in the form of residual oil mixed with sediments, or as highly degraded particles, none of which could reform into floating slicks. And ultimately, she actually rejected every aspect of the case. Paragraph 200, given the absence of cogent evidence before the court, I am unable to accept that the theories of the claimant's experts on this issue were manifest in 2014 or 15 as remobilized oil. There's no evidence of remobilization of any oil, no relevant extreme weather event identified, and contemporaneous reports that might give credence to the possibilities identified. I do, of course, understand my lords are concerned with the point of law on this appeal, but it's interesting to see the context, particularly as my lords say, what is the practical significance? As to the 2 individuals, Interestingly, Mr. Jalla and Mr. Chujor both claim to have properties on the shoreline. They said slightly later in the proceedings, oh, we've also got properties inland. So they claim to have both. They say that as the shoreline properties are concerned, the oil first hit their properties a year after the spill, in December 2012. Based on the findings of the judgment, that simply can't be true. And secondly, if it did reach their land, it couldn't have stayed there for years and years. Where's the bit about their criticism? Yeah. And, my lords, if I just invite my lords just to glance at paragraph 63 of this judgment. 63 of the judgment, please, which is at page 6534. I don't need to read it aloud, but I would invite my lords to read it. Just to say that if my lords are being asked to draw inferences from witness statements of either of these two gentlemen, my lords should be very cautious about doing that. And there's whole histories about the evidence in this case, which some of which are reflected in the judgments here, judgments of Mr. Justice Stuart Smith, Court of Appeal. My lords, we submit there's sort of two big points we want to make, and then I'll deal with some points that have been raised. The first is what we're going to term it cause of action point, but it could also be termed differently. But I'll call it cause of action point, and the second big point will be the principle of control. And cause of action point is really just what I spelled out a few minutes ago, that a cause of action requires the elements of the cause of action to exist, pretty basic proposition. And if it's a continuing cause of action, it requires them to exist at different times, or continuously exist, or be repeated. A word, if I may, about language. Because there are linguistic difficulties or ambiguities at the heart of this appeal, and we respectfully invite my lords to recognise the need for precision in language. It's inherent in the subject matter of nuisance, because it's often described in different ways, not just because there's private nuisance and public nuisance, but also because people and courts differently describe nuisance at different points. Sometimes it's used to describe the harm on the claimant's side. Sometimes it's used to describe the state of affairs on the defendant's side, as in Sedley-Denfield. Sometimes it's both. Professor Prosser, and my lords have his article, it's actually an extract from the textbook, at page 6064. Let's have that. I just give the reference and then I'll just read the relevant words. He says that nuisance is a term which has been surrounded by much confusion. There is perhaps no more impenetrable jungle in the entire law than that which surrounds the word nuisance. So at the top of the page. So at the bottom of the page, and then just reading over the page before one gets to the reference to history. And we respectfully submit that the claimants and the appellants are exploiting these linguistic differences. One other extract I would want to take my lords to is from Professor Fleming, which is at page 5907. The Fleming's Law of Torts. And it's quite useful, we would respectfully submit. He says, it's the paragraph which starts at the bottom of the page. Another perplexing feature is the word nuisance is commonly used in several distinct senses. May I invite my lords just to read to themselves to the end of that paragraph. because we suggest that last point, that there's a danger of this approach because it encouraged the tendency to assume that once a given situation can be characterized as a nuisance, you end up thinking that that's all you need to show. And as Professor says, the mere tagging of a problem with the label of nuisance doesn't provide an easy shortcut to the allocation of responsibility. And we say that's what's happening to some extent here, is my own friends are saying, well, there's a nuisance and therefore that's the end of the matter. And this is why they try to suggest that what happens on the defendant's side is irrelevant. Lord Justice Coulson, in the Court of Appeal, was right, we respectfully submit, and this is at paragraph 52 of the Court of Appeal judgment. Page 211. He was right to say, to say that a cause of action is usually a single self-contained package of rights relating to an act or omission which has caused damage and is actionable in law. In other words, an actionable nuisance requires the presence of all the elements of the tort. And this is why we've labelled this part of our submissions cause of action, because we respectfully submit it's necessary to focus on what is the cause of action. Is it repeated? Is it continuing? And it's all the elements of the cause of action. The appellants, on the other hand, consistently say that the nuisance is the harm. An example is given at paragraph 48 of their written case, and I think in their final paragraphs as well. You can't say the nuisance is the harm and that's it. If you do that, for example, one thing you do is nuisance then becomes indistinguishable from every other tort, including negligence, Rylands and Fletcher, or whatever else. My own friend made a comment about the derivation of the word nuisance. Can I take my lords to the seminal article of Professor Newark, which we have at page 6016. The article is, my lords will know it, it's a very influential and important article, and we would respectfully invite.
This is the one like Martin Luther's 95 Theses that gets nailed to the door of the court.
Yes. And defended, as my list of Dr. Baker's around, defend against all comers.
Yes.
Yes. But the point that my learned friend referred to, we can pick it up from, because he referred to the Latin derivation of nuisance, and this is in the middle of page 6016. They note, he says, authors note that the term nuisance is derived from nocumentum, meaning harm, and hence the wide signification. But he goes on, this is etymologically correct, and this sense we might describe the whole of the law of tort as the law of nuisance. But though the layman of Chaucer's day may have used nuisance to mean harm, we may safely say that no lawyer has ever spoken of a trespass or a defamation or a conversion as a nuisance. To the early lawyer, nuisance meant a very special kind of harm, which he was able to define with particularity, and the aim of this article is to show how many of our present troubles are due to an improper extension of the term nuisance to cover cases which have little in common with the original conception of the tort. Not so much the last bit that matters, but simply it's not going back to the original, to the Latin. Etymology doesn't assist in the exercise placed before my lords. On that point, though, is nuisance the harm. We also have the authority of Lord Atkin in Sedley Denfield. I have to come back to Sedley Denfield, but yes, so I'll just give the reference now, because I'll come back to it. It's at page 5201. My lords, there are two versions of certain of the authorities. There's a core bundle of authorities, and if any of your lordships were using that core, then I would give the references to that. Otherwise, I'm getting some negative responses to
I
that.
haven't done for 4 years.
Well, I think it's an electronic core as well as a
Yes.
hard core, but in any event, in the main authorities at page 5201, and Lord Atkin there says, and I quote, "There must be something more than the mere harm done to the neighbour's property to make the party responsible." Pretty basic point, but it's just to underline that the nuisance is not the harm. Huh? Not just the harm, of course it's part of it. So what I then want to do is then ask the question, well, what are the ingredients of a single cause of action in nuisance, and then go to the question, what about a continuing cause of action in nuisance? Now, our submissions on this are set out in our printed case. Obviously, I don't repeat or read the printed case. My lords have it and have read it. We set this out at paragraphs 29 to 56 of our printed case. And we identified two particular things which must be present. One is there must be an act or omission on the defendant's side, usually arising from the defendant's use of his land. And secondly, there must be a harm or an interference on the claimant's side. And that appeared, for example, from what Lord Newburgh said in Coventry and Lawrence, which I think my lords have been taken to already. So the reference is page 3330. I'll just read it without going to it. A nuisance can be defined as an action or sometimes a failure to act on the part of a defendant which unduly interferes with the claimant's enjoyment of his land.
That was paragraph 3.
That was paragraph.
Reference.
Yes.
I don't have the paragraph. I think it is from recollection. I don't have it in my notes. And obviously, when he talks about nuisance, Lord Newburgh meant actionable nuisance. In Hunter and Canary Wharf, I don't need to take you to that either. I'll give you the reference. For an action in private nuisance to lie in respect of interference with the plaintiff's enjoyment of his land, it will generally arise from something emanating from the defendant's land. So again, enjoyment on one side and something happening on the other. Both sides of that equation need to be present. Now, one could term that, and indeed at one stage I was going to term that, symmetry. And of course, Fern, in which a number of my lords were involved, does use that language, talks about symmetry. I think indeed in the dissenting opinion of my Lord Sales, and with which my Lord Kitchen agreed, I think symmetry is used, but I'll come back to that. Lord Leggett in Fern, and the reference there.
Explain.
What?
Explain.
Yeah. That's where Lord Leggett deals with the principle of reasonable user, because that was at the heart of the difference between my lords as to the disposal of that particular case, but what was reasonable user. But Lord Leggett refers to it as the unifying principle underlying the tort.
Yeah, I mean, for what it's worth from memory, when I talked about symmetry, I'm not sure I was talking about the symmetry you're talking about between the two elements needing to be present. Yes. I think it was more about symmetry between the neighbours.
Yes.
I'm not sure it matters.
Well, my lord, I'm very much obliged, and I apologise for reading too much in. The critical point, though, is made just by the observation my lord has just made. We're concerned with the relationship between two neighbours, the land on one side and on the other side. I have a question as to the importance of land, and that's part of the respondent's notice, of course. I'm not dealing with that at the moment. And the principle of reasonable user, which is, we say, is a critical element, however, whatever its correct content is, a critical element in the law of nuisance, also appears very clearly from what Lord Gough said in Cambridge Water, a case I will have to come back to. And he said, and the reference is at page 3278, he said that liability and nuisance has been kept under control by the principle of reasonable use. And my learned friend referred to that principle, the principle of give and take as between neighbouring occupiers of land. Now, what that means is that not every interference with the claimant's enjoyment of his land will be an actionable nuisance. That obviously appears also from Fern. The case of Southwark, which the thin walls case, if I may call it that, that showed that even though there was an interference because of noise levels, there was no actionable nuisance because the defendant's use of the land was ordinary in the circumstances, or reasonable in the circumstances. I don't want to get into the debate in Fern as to quite how to deal with that. There's an article by Murphy, isn't it? Yeah. There's an it's Professor Murphy's book, and we have the reference at page 6414. It's the law of nuisance. It's just a sentence. I just read it at. He identifies these control mechanisms, and at the top of 6414, in paragraph 1.15, he says, taking the idea of reasonable user first, it's classically understood to relate to the question of give and take between neighbouring landowners. Focuses in two directions at once, towards the nature of the defendant's activity and towards what is reasonable in all the circumstances to expect the claimant to put up with. It's, in short, a control mechanism ultimately concerned with competing uses of land between neighbours who are in close proximity and is intimately bound up with the normal live and let live of neighbouring landowners. He then starts to talk about non-natural use of land, and I don't think I need to take my lords to that just for these purposes. But it underlines, it simply cannot be right that all there is in nuisance is harm. It cannot be right that that's all that the law of nuisance focuses on, is the harm to the claimant. The unifying principle looks in two directions, towards the defendant's conduct, and conduct can, of course, include omission, and I'll come back to that, and the claimant. It cannot be true that all that matters is harm on the claimant's side. And that's actually clear from Lord Neuberger's classic definition, because that shows it requires an act or omission on the defendant's side. I don't need to go back to that, my lords have seen that. Now, if one looks at the decided cases... Just give references. What? Deal with this at the end. Okay. I'm just going to, I don't take my lords to these cases, but they'll be familiar, and I'll just give the references to them. A number of examples where one looks at the defendant's side of the equation. Halsey, that's the references at page 3717. That was the defendant's conduct in running an oil storage issuing depot that emitted noxious fumes, oily smuts, and loud noises from an oil storage and issuing depot. That was a bad smell, damaged the claimant's car, etc. In Piper and Clifford, Kent, page 5073, the defendant's act was running a poultry farm that emitted smells, noises, dust, and feathers. In Sedley Denfield, of course, the omission was to fail to unblock or remove a pipe on its land which resulted in the flooding of the claimant's land. I have to come back to that case, of course, but it's important, but that's what the conduct was. And the other important case, Delaware Mansions, the omission was to fail to remove the tree or to prune it sufficiently that the roots ceased to desiccate the soil. Principal distinction. We can do it. Okay. Now, our respectful submission is that the point is consistent across all the authorities. A single cause of action in nuisance requires an act or omission on the defendant's side, giving rise to harm on the claimant's side. Now, it will usually be clear where what we're talking about is a positive act by the defendant, what my learned friend would term the creation of the nuisance case. What is sometimes less clear is where it flows from an omission by the defendant. And that's where we get close to the principle of control. And I'm going to have to come back and spend a little time on that. But for now, it suffices for me to say that the question of whether there's been an omission on the defendant's land, an omission by the defendant is closely linked to the land or premises under the defendant's control. And this is where one gets the concept of measured duty, which goes back to Goldman and Hargrave, the burning tree in Australia, because the defendant is there under a measured duty to ensure that hazards on its land, whether they're naturally occurring or otherwise, again, leaky and national trust again, do not cause harm to neighbouring land. Now, those are factual distinctions between, as it were, creation and allowance, if one wants to use that expression, but there's no principled difference between them. In both cases, the defendant has done something on his land or failed to do something on his land, which then leads to damage, interference on the claimant's land. So we say it's clear one cannot just look at one side of the equation. That's why we say it's meaningless to say, and wrong to say, that the nuisance is the harm. So, my lords, that deals with the constituent elements of a single cause of action. I wonder whether my lord the President had a question for me. I was misinterpreting.
There's no requirement, is there, for the single cause of action that the conduct, be it act or omission, and the harm are simultaneous in terms of time?
No, need not be.
No.
And therefore you can have a delayed result of some conduct by the defendant, which then causes interference with the claimant on his land.
Yeah, I mean, Dali is an example of that. I mean, even the first cause of action, the damage to the cottages from the subsidence,
yes,
wasn't contemporaneous with,
yes,
with the digging out.
Yes. And I come back to Dali. I mean, Dali's actually, the fundamental point about Dali, which dare one say, it looks as if Lord Blackburn actually failed to spot, there was an omission by the defendant, which was the failure to maintain support. It looks as if he might not have, my lord is looking at me as if a heretical statement I've just made, but when we come to it, that looks as if it may be why he formed a different view from the other members of the House. But in any event, it was an omission. We say the important thing was that, yes, there was excavation, but they were at pains to point out that the excavation was not wrongful, fully entitled to dig out the coal that was in the seams that belonged to them. But if you fail then to leave support, and so the land, because it's got no support, subsides, then there is a cause of action. You will have to have damage in order for the cause of action to be complete, like any other tort, which is an action on the case. So the damage is necessary to complete the tort, but the point is that if there was an omission, a failure, we respectfully say that's the correct understanding of the case.
I think the key to that may lie in whether the failure was contemporaneous with the original excavation, or whether there was an ongoing failure.
Yes. It appears from the report it was ongoing.
Well, that's where I'd like some help at some
stage.
Yes, well,
we look at, yes.
Because if it was a contemporaneous failure, in other words, you're digging a seam and you don't leave enough pillars, that's something you can only, I think, do when you're digging the seam, because you haven't left enough pillars, well, you haven't left enough pillars.
Well, you can put other things in.
Well, the question is whether there can be some continuing miners' failure to maintain or put in pit props at some later stage.
I think you'd have to look, in the particular case, at the configuration of the mine, but bearing in, I'm speaking a little bit from past experience dealing with substance cases. I mean, you dig a big hole because you're taking the coal out, and then you need to leave some support. It could be natural support, because there could be sufficient arch of coal left to keep the land up, or you put in different forms of supports.
That's certainly so. The question is whether that's in practice be sort of done after the event, or whether it's something that has to go along.
If you've still got access to the mine, I don't see why you shouldn't be able to do it after the event. I mean, you still have the shaft.
But you're going to get to Dali tomorrow, presumably, or maybe today.
Yes, my lord, I'm going to, yes, I am. So I've tried to deal with single cause of action, and I now want to deal with continuing cause of action. And we say that's really quite straightforward. There's no magic in this. There isn't a separate category of continuing nuisance or something. It's just a continuing cause of action requires a recurrence of all the constituent elements of the tort. And therefore, a continuing nuisance will not be made out just by showing the recurrence or persistence of harm on the claimant's side, or for that matter, by a repetition of an act or omission by the defendant. You need both sides. Question, as my lord puts to me, do they need to be contemporaneous in time? No. But they have to be connected in that way. So there are several cases which explain that, which I want to take my lords to. Whitehouse and Fellows is the first, which we have at page 5508. I have tab numbers, but it may be your lordships don't, and therefore there's no point in my giving those references.
They're not really terribly helpful. We do actually have tab numbers, but it's quicker to give us the page.
Thank you, my lord.
Thank you.
So anyway, the case starts at page 5501. Now, the case starts at 5501, and then I wanted to take my lords to 5508, which is the judgment of Mr. Justice Williams. Take it from the bottom. I'm just trying to see where I should take my lords to. I think at the bottom of the page, with the paragraph which starts in considering the first point, I assume that an injurious act was done to the plaintiff by reason of the defendant's improper management of the catch pits, whereby the water which ought to pass down the drain was caused to flow into the plaintiff's pits. The question is whether the plaintiff is bound to rest his complaint upon the original construction of the works, or whether he can maintain an action after the expiration of 3 months from that time. I'm of opinion that the continuance by the defendants that negligent and improper condition of the road under their charge, if accompanied by fresh damage to the plaintiff, constitutes a fresh cause of action. So not contemporaneous, but they are the two things that are taking place, and the damage is taking place, so that completes the cause of action.
My slight concern with the way this argument is progressing is that you can surely have cases where there is no repetition of an act, nor is there an omission. And yet, we can talk about a continuation of the cause of action because there is fresh damage. And the example I was giving before, just so you've got it in your mind, was, I think we were referred to an example, but if you do take the Sedley-Denfield example and think of the trespasser who initially creates the problem, and let's just assume that carries on and is causing fresh damage to the claimant's land.
Yes.
That is, if I might put it to you, one act by the defendant, and yet continuing harm.
But not a continuing cause of action, and that's the point. I'm obliged to my lord, because I was going to make it a little bit later on, but I'll make it now if I may. There's an important difference between what damage the defendant is liable for and whether there is a continuing cause of action, i.e. a new cause of action, which will help you escape the limitation. It doesn't matter otherwise, generally, whether it's a continuing cause of action.
Well, in that example, I would have thought that there would be a new cause of action accruing and therefore a new limitation period arising from the subsequent fresh damage.
Well, so be it, and that's rather what Lord Halsbury was saying in Dali. But the reason that it's a tort is because there is a continuing failure by the defendant to deal with the culvert on its land.
Well, what if you were suing the original trespasser?
Yeah.
Sorry, my lord.
What if you were suing the original trespasser?
That's my point.
Well, assuming
That's what I thought Lord Barrows was
well, the original trespasser is still liable for all the reasonable consequences of his act, subject to remoteness and limitation. So if you injure somebody, you'll be liable for the consequences. You may need to, the court might need to assess the damages prospectively. It might need to make an assessment.
But I think what I'm putting to you is that your emphasis on always needing a repetition of the conduct element may, strictly speaking, be only one part of the picture. It doesn't defeat your main argument, but it seems to me that you can have continuing torts, and in this example we're talking about continuing nuisance, where there is no repetition of the act, there is no omission, as in the trespasser example, and yet there is regarded as a continuing cause of action because there's fresh damage.
But my lord says continuing cause of action giving rise to fresh limitation. That's the question I'm focusing on.
Yes.
Or which gives rise to a new interference.
Well, it may give rise to new interference, and if one takes what Lord Halsbury said in Dali, that may give rise to a new cause of action because there's new damage.
Yeah.
But that was accompanied still by conduct by the defendant.
It was on that, arguably on your interpretation, you say, well, Dali, it's important that we do see there's a continuing omission by the defendant
Yes.
to actually put supporters for the land.
Yes.
I think it's put against you that isn't a crucial part of the reasoning. And what I'm suggesting to you is maybe it isn't a crucial part of the reasoning, because if we think of a different case, i.e. suing a trespasser, where there's no question of a continuing duty, no omission, nevertheless, you would think that there was a fresh limitation period running because there was a fresh cause of action when you get different damage caused on the claimant's land.
My lord, the difficulty I'm having, and I'm sure it's my fault, is the context in which you'd be suing the trespasser other than for damages for the consequences of the original act. And if that's what you're doing, no problem, because he will be liable for all of that, subject, as I say, to remoteness and limitation. But he caused the original act, so he's liable for that.
Well, the question is, if you're suing him outside the limitation period.
But what? I'm being assisted here.
There's no question he's liable.
Yes.
It's a question of, are there two causes of action?
Yes. I mean, sorry.
Yes.
Sorry, you listened to that, and then I'll...
No, my lord, it's your question that matters, my lord.
Well, it was more an observation. I would have thought that a great deal might depend upon how you characterise the damage, whether it's continuing or whether it's fresh damage. Because, I mean, we're going to look at Dali in more detail. I don't want to divert you too much into that. But one principle underlying Lord Blackburn's judgment was that he thought that as soon as there was any damage from the subsidence, you had to claim for everything at that point. Whereas the others seem to have thought, no, you're not bound to claim for everything. You may not know what the full damage is at that point. So, in essence, they were saying you had to claim for whatever was for your foreseeable loss at that time and bring everything in at that point. And you could, and you should. But where there was a, if you like, completely separate a set of damage that flowed later, and in Dali it was a separate substance many years later, that was a new item of damage, and therefore there was a new cause of action, following your analysis, composed from the fault, which was the fault many years before, or in Lord Barrow's example, the fault of the trespasser. That doesn't go away. It's just that there's a new package of damage that comes in that constitutes the new cause of action.
Yeah. If I could add to that, Lord Halsbury talks about the difficulty, where he says there might not be any further damage. So it's a part of his thinking is the impossibility of predicting whether there ever would be further subsidence. In these days, as I dare say, expert engineers would tell you, but in Victorian England, it may have been a different story.
Yeah. I mean, I know you're going to come on to it, but there's a very interesting sort of debate between Lord Justice Fry and Lord Blackburn, where Lord Blackburn says, well, Lord Justice Fry states the principle, i.e. that you sue at one point in time for all your loss and you can't hold back and then come back later on. And he says, well, that is the rule. And then he applies it in the facts of Darley to say, well, you were just stuck with suing for everything, even though you didn't know about the future loss at the first point in time.
Yeah.
And the others were unattracted by that. But it's still, the principle was, where you've got a cause of action, you sue for everything at that point in time.
Yes, Lord Halsbury draws an analogy with a neighbour who has a dog that bites, and he talks about how absurd it would be if a dog bit you once and you then had to bring an action for every possible future bite that you might suffer.
Yes, I mean, of course, the difference we're concerned with is not so much can you bring an action for, well, no, I'm not sure that's right. I haven't thought about the dog biting example. I need to. Can I just finish this? I think I will come back to Darley, and it's obviously an important case. Though interestingly, despite the fact my learned friend describes it as the most important case, it wasn't referred to below at all. But there we are. That happens, I suppose.
Yes, I mean, the dog biting example may be of interest because it shows how they thought about subsidence 150 years ago.
Yes, it may be. It may be. And there's a focus in that about the lawfulness of excavating the coal, and therefore the excavation of the coal could not be a wrong. Maybe that's where we're not quite there. Just still continuing, if I may, on continuing cause of action, I want to just take a couple more cases to... well, just one more. Can I take Whole and Charge Union? It's a Court of Appeal case. That's to be found at pages 3773 to 3774. And there we have the statement. Can I just take my lords to the judgment of Lord Justice Lindley on page 3773, and whether the question was whether the damage sustained by the plaintiff since the judgment for an injunction came into operation is to be taken into account in assessing the damage in the action. And the nuisance complainant was the pollution of a stream flowing through the plaintiff's land by the discharge into it of sewage and refuse. Mr. Justice Chitty granted an injunction. Let's pause at that because, of course, that's a way of testing whether there's a continuing tort, continuing cause of action, whether a court would grant an injunction or merely would then say, well, there's damages that flow from the initial act, and so you're going to get them now. And then at the bottom of the page, there's discussion of Order 36, Rule 58. Now, I've tried to research this a little bit, but until that rule, which says that in a continuing cause of action, you can get damages down to the date of assessment, I presume the position in law was that even if it was a continuing cause of action, you were limited to the damage that you'd suffered at the date of the writ, or whatever it was, the originating process. But I don't know, it's only a deduction from the fact that this rule was then introduced. In any event, that's why they have to ask the question whether there's a continuing cause of action. And what they said was, what Lord Justice Lindley said, and the court concurred, a continuing cause of action is a cause of action which arises from the repetition of acts or omissions of the same kind as that for which the action was brought. And that's a continuing cause of action. What did I say? Oh, thank you. And this is actually a nuisance case. Thank you.
though it's the sort of smells or noxious escapes type of nuisance case. As it happens, I mean, it's allowing sewage and
Yes.
stuff to...
Well, I mean, ours may be slightly different, but it's the same character, it's the same nature of discharge. It's not sewage, but it's allegedly noxious oil. Slightly hesitant about the next citation, but I'm going to just give the reference in any event. It's a Law Commission report on limitation. And it's at page 5956, where the Law Commission captured the point about continuing claim by saying, a continuing claim such as nuisance, where a fresh cause of action arises with each subsequent act by the defendant. And I obviously approach that with a little diffidence, as I'm not sure the extent to which my Lord Boroughs.
Where's the quote, sorry?
It's from page 5956.
5956.
That's the page. The paragraph I haven't got in front of me.
This appears to be proceedings under section 459 of the Companies Act. 5956, did you say?
5956.
Yes.
I'm not sure that's the right reference.
I don't think that can be
Oh
right.
dear.
Interesting.
I'm going to make this good now. Is it? Well, it's at the bottom. It's paragraph 4.214. It is about section 459, that's true. But it's the analogy that is then drawn with a continuing claim in nuisance. So,
Oh, I see. It goes over the page.
yes, it goes over the pages. Yeah. Well, all I'm saying is that is consistent with my submission. It's consistent with whole and charred union. And it's for your lordships to judge how much to rely upon that.
I suppose you could have two separate fault elements that feed into an overall damage element,
Certainly.
where it may be difficult to separate
Certainly.
which is which, so that the sort of symmetrical approach to saying, well, you can have one fault and then two damages, two separate losses, so that would be separate causes of action if you analyse it in that way.
Yes.
One might be able to say you could have two separate fault elements, even though there's one sort of grouping of damage,
Yes.
and you could have two separate causes of action that way as well.
I suppose, I'm not sure this meets my lord's point, but you could have two different people damaged by the same act.
Yes, I was making a slightly different
Yes,
thing,
I-
looking at one
Yes.
sort of set of damage,
Yes.
but with two causal
Yes.
things which have fed into that.
Yes.
Yeah, all right, thank you.
Yeah. So I've got. I think in the short time remaining today, I can just round this point off by taking you to my lords to one other case, which is Clegg and Dearden, and that tells us, and I'll take my lords to it, that there can be no continuing cause of action in nuisance based solely on the fact that the defendant has failed to remedy the consequences of the original act. Not sure that's... At one stage that was being argued by my learned friends. I don't think it is anymore, but it's worth just perhaps taking my lords to this. It's at page 3312, 1848. It's another coal mine. Yeah. Yeah. So what, the facts here were there was an excavation, but the complaint about it wasn't so much that it let the land down, but that the aperture created by the excavation was letting the rain or the water or something in. And the argument was that there was an obligation on the defendant to close up the aperture he'd created. And if you go to 3321...
Sorry, 4321.
3321.
Thank you.
And we see there, and I think this is the judgment of Lord Denman, Chief Justice Lord Denman. He says the gist of the action is that keeping open and unfilled an aperture, an excavation made by the defendant into the plaintiff's mine. By the custom, the defendant was entitled to excavate up to the boundary of his mine without leaving any barrier. And the cause of action, therefore, is the not filling up the excavation made by him on the plaintiff's side of the boundary and within their mine. So this was not filling up on the plaintiff's side, not on the defendant's side. It's not as in the case of Holmes and Wilson continuing or something wrongfully placed by the defendant on the premises of the plaintiffs, nor is it a continuing of something placed upon the land of a third person to the nuisance of the plaintiffs. There is a legal obligation to discontinue a trespass or remove a nuisance, but no such obligation upon a trespasser to replace what he's pulled down or destroyed upon the land of another, though he's liable in action of trespass to compensation damages for the loss suffered. The defendant, having made an excavation aperture in the plaintiff's land, was liable to an action of trespass, but no cause of action arises from his omitting to re-enter the plaintiff's land and fill up the excavation. Such an omission is neither a continuation of a trespass, nor of a nuisance, nor is it a breach of any legal duty. Now, you may have to pay damages for that, but you're not under an obligation to go and do the work. And that's relevant here, because one of the complaints that the claimants make, and you heard them talk about remediation, they say we should have remediated, which involves actually going onto their land and clearing and doing whatever else they say should have happened. There's no obligation to do that.
You've no entitlement to.
Indeed, we have no entitlement to do it, and it's no use saying we invite you to. We've still got no entitlement to do it. When it comes to a claim for damages, should we get to that, well then, of course, that may be relevant. The cost of doing it, the fact we weren't prepared to do it, whatever it may be. And it may be open to us to try and mitigate, but it doesn't matter whether we mitigate, that's not the point. But in any event, there's no duty to do it, and no entitlement to do it. And I just want, if I may, this is, yes. And this is, just to round off this point, if I may, I'll come back to Darley, but can I just remind my lords what Lord Justice Coulson and indeed Mr. Justice Stuart Smith said in the courts below. At paragraph 53 of the Court of Appeal judgment, he said that their claim failed because it didn't have the essential elements for a continuing action in nuisance. And he said, at paragraph 53, the underlying notion, I read, that a continuing cause of action will usually involve a repetition of the acts or omissions which give rise to the original cause of action, continues to make logical sense in the 21st century. We very respectfully agree and commend that to my lords. And rather more shortly, in the judgment at first instance, at paragraph 67, just turn that up. Mr. Justice Stuart Smith, as his lordship then was, he then deals with Sedley Denfield and with Delaware Mansions, which I have to come back to now tomorrow morning. And he says at 67 that the determining feature of Delaware was the continued presence of the tree roots, which gave rise to a continued need for underpinning, which would have been avoided critically if the Highway Authority had abated the continuing nuisance. We've had this discussion, my lords have raised this already with my learned friend today. Just reading on, it would have been avoided if the Highway Authority had abated the continuing nuisance by removing the tree, I would add, or by lopping the branches, which could have the same effect. And the highway authority became responsible for that continuing state of affairs on being notified of the problem and declining to abate the nuisance. And that's analogous to the person who builds and leaves a structure overhanging his neighbour's land. That's Battishill and Reed, which is what's called the classic case of continuing nuisance. That's leaving an overhanging structure over your neighbour's land. And Mr. Justice Stuart Smith says, there's one occurrence of nuisance for which all damages must be claimed at once, even if the consequences of the nuisance persist, and then makes reference to Sedley Denfield.
So just thinking aloud, if to take some classic examples, if you have a cricket club in which balls get struck into a neighbour's garden,
Yes.
and there's a cricket match every Saturday afternoon,
Yes.
then there'll be a repetition of the nuisance every Saturday.
Yes.
And if you bring a claim against a cricket club, you can only recover for broken windows in your greenhouse and so on, up to the time when you bring your claim. You can't claim for future breakages.
I would think that's right.
Now, if you alter the facts slightly, and if you think about, say, a storm drain, or say a sewage system, which is going to overflow and pollute land or water during a storm, and that might happen every 6 months, roughly. You haven't got the human agency involved in the cricket example, but you've got a continuing omission, if you like, to remedy the inadequacy of the system. And there again, you could only recover for flooding that had occurred as a result of storms up to date, and you could bring another action in the future if, after you'd received your award of damages, the problem continued.
Yes.
If, on the other
You could do one more thing, my lord. You could ask, forgive me, you could ask for an injunction in both those cases.
Of course you could. If you, on the other hand, are talking about, say, a spillage of oil, which either destroys or diminishes the value of land or ponds for farming, so that you lose the stock that are in them at the time of the pollution, and also you're going to have a continuing loss of income.
Yes.
Then in principle, you ought to be able to recover your damages once and for all.
Yes. There may be some difficulty in assessment, but it's a common feature of large actions that you look to the future as well as the past, and you make, perhaps with the help of experts, assessments as to what's likely to happen, and complicated calculations, as one does in personal injuries cases all the time.
Yes, and you would only bring a further claim if happened to be further pollution.
Yes, yes, my lord, exactly so. We respectfully agree. My lord,
well, if that's a convenient matter.
well, if it is, my lord, I was pausing at around this time for that reason.
Yes, very well. Well, in that case, we'll adjourn for the day and sit again at 10:30 tomorrow.
Thank you, my lord.